Okay, now I see myself. Good morning, everybody. I want to thank all those who have come here this morning to the studios to discuss some important issues of international arbitration. I also welcome the ones who will join us online. This is already the eighth arbitration hearings after Academician Pobirchenko. This is a heroic deed in a way because in the recent years it was not very, it was quite a difficult event, but we have successfully, as we can see, following the seventh arbitration hearings where our broadcast was watched by more than 1,000 visitors online. That's why we believe that we have implemented our mission. And I think that the arbitration hearings, well, if you have certain circumstances, are becoming the main message, Ukrainian message, as regards international arbitration. And I'm happy to know that. Once again, I want to thank you for being interested in our hearings. The subject that we're discussing is always an important thing, and to choose it is also quite controversial. We have thought quite a long time, the organizational committee, and that's in fact the board of the ICAC, to decide which interesting we should be discussing so that it would be interesting for everyone. We have studied world trends, the trends in the development of international arbitration, and we have decided, well, of course we've studied the Ukrainian reality because we live in a real country and we have to watch arbitration develop in this country, not only the way how it is developing, but also to take care of its development in Ukraine. That's why we have chosen two subjects, which I hope would be interesting for all of you. The first one is what new things can we see in the international arbitration in the recent years, what challenges there are, those recent arbitration events and developments. And first of all, I'd like to focus on that. Many of you, including the moderators, Amirat, Markian, in the interviews that were published by the Legal Practice newspaper, and incidentally, I advise you to read those interviews. They are quite relevant and interesting, and incidentally, that's already the second hearings where the moderators, on the eve of it, give interviews to newspapers, and that shows that they're qualified, that they are well read, and it shows that they propagate our arbitration reading. So the moderators have also said that COVID, or rather COVID, has forced arbitration to take certain dramatic steps in order to be competitive amid the pandemic. And I think that this is not exactly so. International arbitration, the world arbitration, is headed by smart, qualified people. I'm saying is headed by, not as persons, but as associations, as the community of people, and they watch attentively the new trends in the world development, not only as regards law, politics, arbitration policies, but economy as well, and they feel what should be done. And that's why the biggest world arbitration institutions are ahead, and they are telling the others what should be done. Now, what we are going to be discussing now, what we have implemented in the arbitration process, is already something that was kind of a precondition. We were pregnant with these arbitration trends. For example, the Stockholm Arbitration Institute back in 2019, before COVID started, had suggested an online platform for online case administration. I'm going to praise myself now. Back in 2017, we approved our new regulations where there was a provision on online hearings. And as our facility was underwent a major renovation 8 years ago, we equipped 3 of our rooms, and now they function very actively. We even have certain competition for those rooms, and we plan our meetings in such a way that there would not be 2 or 3 hearings online, because we're short not so much of the equipment or rooms, but in terms of the information technologies. However, as soon as COVID started, what had already been developed by the arbitration institutions and their regulations, they immediately started implementing that, and very powerfully so. Well, I have not counted, but I think about 50% of all the arbitration hearings, the ICAC with the trade chamber, are not completely online, but many of them participate online, whether the parties, whether the arbiters, and there is demand for this service. At the same time, that causes certain problems, because on one hand that's very good, that adds to speed, and that lowers the costs. And of course, now we can engage many more foreign arbiters who participate in the hearings. That's the positive thing. But there are some, well, perhaps not negative things, but some problems that need to be regulated legally, not only in the regulations, but even in the legislation. What's, and most important, in the case law, because it's on the zero level now. For example, online participation. Is there the right in arbitration to demand offline participation in the arbitration hearings? Is there such a right? We've already had 2 cases when a party would categorically state that it does not want to have online hearings. It demands, once again, the party demanded to have offline hearings, especially when we're talking about the arbitration composition, not about the parties, but about the arbitration judges who should listen, who should hear the case online. Offline, I guess. Well, thanks to Yulia Chernech, we have written down in our regulations of 2020 that all of this can be decided by the arbitration judges. So it looks like the legal problem has been resolved. But what will the case law say about that? And I have some concerns. Because, for example, when that decision is appealed, where a party demanded what I have said, when one of the arguments for quashing our decision was that we did not give them the right to express their position, or that the arbitration could not hear one's position normally, I don't know what our judges would think about that. Well, thank God that at the first session we have a special survey about that. We would be very happy to hear the practice of other countries. However, for me, first and foremost, that's the case law, that's the practical approach of the courts. We can talk about confidentiality and all things like that. However, still there are quite a lot of challenges, and I hope that now, when the first session starts, many of those problems that interest us and that are very relevant today, and that have to be somehow resolved through a consensus, hopefully. We can do that. We should do that. The second session looks like it is about the Ukrainian problems, and it is really so. However, these Ukrainian problems, well, we have had a permanent strive to improve everything, to reform everything. But 30 years of reforms, I think that's already too much. I think we have to stop somewhere and keep developing in a normal way like other countries do. I recently heard that in the fraternal Poland, the reforms took place like 15 or 18 months, and their GDP after those 3 years has grown 3 times, while our GDP has gone down, well, I won't even want to say by what percentage point. Same thing about arbitration. There are discussions about how much arbitration there should be, what kind of arbitration should be there, whether we should engage English arbiters that are very well qualified, that nobody would deny that, or have a unit of well-known arbitration institutions in this country. But I think, and let me repeat myself, but I'll be brief, we have to develop our arbitration institutions. We have to promote them. We have to do everything so that they would have proper authority. If there are any deficiencies, they have to be resolved, improved. We have to change perhaps some elements that would not allow us to keep going forward. Because again, there is competition, not in every country among the arbitration institutions. Only idiots would do that. But there is competition the way we have it. But there is competition, I'm about to finish soon, there is competition between arbitration institutions of different countries. And that's why we believe that the development of arbitration in Ukraine should take place by improving the arbitration institute that we already have, by broadening the competences. Incidentally, who can tell me in a simple way up to what boundaries can the state, the government, give its agreement to non-governmental, to non-public dispute resolution, alternative dispute resolution? It's not the arbitration that should resolve it. In every country, the government would put certain limits to those courts of arbitration, telling them that this is a certain category of cases that they can resolve, or all the cases except for such ones. You would know that better than I do. So in conclusion, I'd like to inform you that, thank God, in spite of certain oppression and counteractions that we've had for quite many years, and it was even better when they would not interfere with us, but the arbitration court is going to mark its 30th anniversary or 33rd anniversary next year. This is going to be a set of events where one of them is the legal practice newspaper has had a very interesting survey. The development, the level of development of international arbitration in Ukraine, which the newspaper asked a question about the ICAC and the assessment of its work. You see some preliminary results of the survey where they interviewed businesses and legal firms, which are somewhat different, but some of them are the same. Well, for example, what do businesses say? Their assessment of different aspects in the work of arbitration institutions between 1 and 5. Qualification of arbiters, 4.9. That's what the businesses says, not me. Of course, I like it very much, I also like the fact that 4.6 is how they assess the work of the staff, the secretariat. I criticize them a little because we could not yet introduce electronic paper flow, but the fact that the girls are doing their work in a very qualified way, and what is even more important, they really care together with the parties, and one can feel it. Next is whether the service is comfortable, 4.6. Well, I would not perhaps say that our building is very comfortable. Well, we have lots of rooms, but these rooms are small, and that's a problem for us. And then what has surprised me a little bit is that 2.5% of the respondents said that the cost of arbitration hearing is high. Well, ours is one of the lowest levels, except for Moldova, perhaps. The arbitration fee, that's why. I don't know why they're saying that. What the legal firms law firms are saying. And I would like to talk about arbitration to you so that you would understand all that. Now, what has changed for the better in the recent 3 years? The expert level of arbiters, 40%. My colleagues have said. The regulations have been updated, 44%. Incidentally, in the course of these years, in 2017 and 2018, we introduced it, and in the regulations of 2020 we have updated it. The infrastructure, 12%, that's true, I agree with that. We need to have another building. The reputation of ICAC, international reputation, 28%. That's also quite good, although we have to work on it yet. Access to arbitration, 56%. I think that's the highest evaluation, and we're very happy that we have created this landscape and such regulations that would allow us. Now, support by the Secretariat, 36%. That's also, it speaks for itself. It says that the Secretariat works properly. Dear colleagues, so the second session, where we will be discussing the problems of the arbitration development, looking at the experience not only of Ukraine, but I'm happy that we will have here our colleague from Kazakhstan who will tell us about the arbitration court under the Astana Financial Center. But those of you who do not know, but perhaps you will all know, that recently in September, the Sheikh of United Arab Emirates, the Prime Minister, with his decree, stopped the work of the arbitration center in Dubai, the arbitration court with the Dubai Arbitration Center. As far as I know, they only had foreigners as arbiters there. Well, I may guess what the reasons for that decision were, but this is a kind of a message, a signal that should tell us all that we should bring up our own legal elite that would be capable of solving arbitration problems on a very high level and to speak about its own competence and role. And the last thing, Vladimir, I'm sorry I did not see you. Well, the fact that our arbitration hearings are interesting. Vladimir Brich, a well-known expert in arbitration, who works very actively and runs his own international conferences every year. So he has come here not only to look at the competitors, but because he's interested to know how our arbitration is going to develop. Welcome, Vladimir, and I hope you will find it interesting and perhaps you will participate in the discussions. Amirat? Well, I'll promise that I will criticize you, but I will not. That's why let's work. Thank you all very much. And
arbitration clause with ICAC. I had no clue what that was, but when I came to ICAC's office, first of all, I was astonished by their building, but secondly, I was impressed by how they treated me, how much respect they expressed, the level of communication, the level of professionalism. They treated me as a representative of the party, even though, to tell you the truth, what I brought them was something horrid. It was not a good document, not a good statement of claim, but I could tell that this is the way it actually could be. You could be treated with respect by professionals. You could work in the case, represent your colleagues, and this changed my life. I went to study in England, but at that point, I decided I want to work in arbitration. And all of my colleagues were making fun of me. I became a laughingstock. Well, what kind of arbitration are you talking about? But I was sure of that, and it's been 20 years after that, and now it's my honor to moderate discussion. I'm anxious. Sorry, the microphone was not used. Yes, that is true. Very few people know about that. I'm very anxious, and it's very important for me. Thank you. Long live arbitration. I'd like to commence our session with mentioning the survey that was already raised. Our colleagues from Юридична Практика newspaper looked into arbitration in Ukraine, the level of satisfaction, and there's one more slide which is quite interesting. They asked law firms about what can be improved as a priority in the operations of ICAC. Most respondents said that expanding e-case management and transfer to 100% digitalization. That's probably the answer of the question that was raised earlier. The question about how acceptable that is and to which extent this is pertinent to case resolutions and whether we'll have any problems in the context with demands for offline hearings. And arbitration is dispute resolution per se, but even if we look at Article 6 of European Convention, I don't see any problems with access to court in this context. Secondly, what law firms want, expanding the recommended list of arbitrators, 28%. And it's no coincidence. The list was expanded very recently, and as a practicing lawyer and someone who works in arbitration, I would like to say that as of now, I'm 100% happy with the list of arbitrators. Of course, there's always room for improvement, but to tell you the truth, in ICAC, you can pick some very high qualified arbitrators to work your case, and there's very small percentage of those who are not happy with the list. And expanding the list of products of ICAC, mediation in commercial disputes and services and investment disputes, 20% of respondents wish to see those services provided. I could join them. By far and large, in Ukraine, we need to develop mediation because we have major issues with that. Nobody wants to settle and reconcile. The people want to resolve disputes. They want to decide who's right and who's wrong. And mediation is about reconciliation. And investment disputes, well, that is also a good point. This is a major challenge that our society is presently faced with, because we know what's happening in the world. So most probably there will be more and more investment disputes, and it would be good if our favorite, beloved ICAC could work with those. That was about the survey, and now I think it's time we give the floor to our presenters. And first of all, I would like to give the floor to Mr. Dmitro Koba. He's joining us online. We can see you. Good morning. He's international business developer, Jus Mundi, and he will be talking about new technologies in arbitration process, whether the quality went up. Dmitro, over to you. Good morning. First of all, thank you, the organizers of the readings, for the invitation. This is a great honor for me to be presenting at the event taking place in Ukraine, organized by ICAC. And Aminat said that she's a bit nervous, but I'm in the Paris apartment. I'm looking at the vase with flowers, and you're in the room together with Ksenia, Alexei, and the audience, so I could be even more nervous. I would really like to be with you attending this event, but I thought, since the topic of my presentation is cutting-edge technologies and how they impact arbitration, it would be interesting to show how that happens. All of those Zoom calls, WhatsApp calls, etc. So this is the element of how modern technology is impact arbitration. And to tell you the truth, I'm very open to discussion, and this is quite an extensive, broad topic, modern technologies. For some, this is about AI, codes, and algorithms, but actually they're already around us. They're already affecting arbitration, and the practicing lawyers are in the best position to tell how Zoom, WhatsApp, etc., early into the pandemic helped the businesses, arbitration, not to be suspended. And Jusmundi, we're observing this as an outsider because we are a legal tech company. We work with lawyers, but we have a different perspective. We saw that it was very challenging initially, but then it all went faster. There were hearings conducted, and I believe Ksenia will be talking about virtual hearings and about the quality that these online hearings could have. And actually, once Exceed posted online hearing on Waterfall versus Germany, and the hearing started at 6 a.m. That was an online hearing, and the examination of witnesses was quite a sight to see. And I had an opportunity to observe how technologies helped to continue with work. As a representative of legal tech company, and I think legal tech is a buzzword already, in my presentation I would like to focus on the role and impact of legal tech companies, their impact on access to international legal resources. We are convinced that this is very important. And when I say access to international legal resources, first and foremost, what I mean is access to international legal information, information about parties to international arbitration, arbitrators, experts, lawyers. Regarding access to international legal information, the way I see it, law is public good, and therefore each legal document has to be in open access, available to public. And as far as resources are concerned, arbitration awards, international agreements, procedural orders, where applicable, of course, where confidentiality allows for that. If we look at international law, international arbitration, we have to be mindful of the fact that in national legislation there's no single point of access. Maybe it's better developed in some countries and worse developed in other countries, but international law doesn't have a single point of access to international legal access to arbitration awards in particular. Information about them. And such legal resources have problematic access, not to mention language barriers and difference in national legislations, legal frameworks. So legal tech companies, as far as their role is concerned in international arbitration, it's their task to put modern technologies to good use to strengthen rule of law. And just to give you an example, I don't think there would be anyone to disagree with me when I say that international commercial arbitration is confidential because there's a lot of sensitive information, a lot of companies involved, big companies in particular, and at times they do not wish to disclose information about the arbitration proceedings. There's lots of sensitive information about witnesses, so it was always seen as something confidential, a confidential system. Jusmundi company, I think, is starting to change this a bit with help of arbitration community, global community. And if we look at the international ICC policy about publication of international decisions, and there's actually a unique agreement that Jusmundi signed with the ICC on the publication of arbitration awards. This is something new, something revolutionary in the area of access to international law resources. The agreement is about ICC publishing their decisions, and many institutions are interested in that. There are cases on the website that you can see And at times it's general information about the case, other times you can find the arbitration award itself. And arbitration institutions, as already mentioned, they're interested in having the arbitration decisions published. It's just the problem is, how do you do that? How can we protect the confidentiality of the parties? And I think that Alexei will be talking about this. How can we make sure that everything is published in time, free of charge? Because we know there are a lot of resources that have restricted access to international decisions, and you have to pay to get the access. So the idea of the agreement was publishing the decisions using on the platform with help of pseudo-anonymization, the way we refer to it, pseudo-anonymization of the sensitive information. The witnesses this information about arbitrators and lawyers, and at the end of the day, what we have is that the legal text itself, which is very important for the issue of precedence, even if precedence international arbitration is not at the same level as international criminal law, for example, and so on. But nonetheless, the more decisions, the more documents are made publicly available in international arbitration, the more we could be talking about precedent, and we will be able to refer to previous decisions in arbitration. And this could be the role and impact of legal tech companies in access to international law tools. Another thing is access to the database of arbitrators. This is something very interesting, and as you probably know, there are also heated debate about that, conflict of interest, arbitrators, etc. And there is a place for legal tech companies, because there's a place for modern technologies in this process, the databases of the arbitrators, where you can look up the cases that the arbitrator took part in, collected information about parties to the arbitration is much simplified due to modern technologies. Also, you could look up what arbitrators said on specific issue. You could look up whether they know much about construction industry, for example, or you can identify potential conflict of interest. This is also good for the transparency of arbitration, because investment arbitration is heavily criticized at times. There are a lot of cases versus the states, high-profile cases, corruption, political elements, etc., etc. And these databases could help you see who's going to be making a decision in the case. You could look at the experience of the arbitrators, and this all fosters transparency of international commercial arbitration. This is also a good opportunity for young arbitrators who want to have a career. This is a good opportunity for them to be appointed to arbitration, to get a case, because there are more and more companies that have the databases, help foster transparency in arbitration. But in investment arbitration, very often we can see the same faces, the same arbitrators in all the big cases, and I think this is something that has to be changed. This also brings me to the issue of gender equality, because I think only recently in investment arbitration, for the first time ever, the arbitration tribunal consisted of women. And this is also a significant issue, and there's a role for legal tech companies in improving access to arbitrators. And To recap, I'd like to say that there's a place for lawyers and experts also. The market of international arbitration is growing exponentially. The number of the cases goes on the rise, and regardless of the COVID pandemic, the number of the cases still goes up. And the number of lawyers specialized in international arbitration is also going up, which means that the lawyers are looking for new clients. The clients are looking for lawyers to represent them in the cases, and the matter of finding a lawyer from a specific country with specialization could be quite a challenge. Legal departments of various companies tend to look for professionals without paying too much. And to be frank, based on my experience with arbitration and as an outsider, Ukrainian lawyers are highly professional, that are no worse in investment commercial cases than their Western colleagues. So I agree with Mr. Salivon. We indeed need to raise awareness about Ukrainian lawyers, Ukrainian arbitration globally, including investment disputes. I think this will be discussed at the second session, but it would be very interesting to hear about that too. So to sum up this brief presentation, and sorry if I took too much time, I think legal tech companies have a role to play in international arbitration. They can help with transparency, with ease of access to international arbitration, because with help of modern technologies, international arbitration becomes more accessible to lawyers, which helps look up and find international law resources, helps with the adversarial process. It's a chance for young lawyers to be assigned to the case, and for students, future lawyers, this also provides more access to arbitration awards, procedural rulings, and records of hearings. And I think at the end of the day, it's all about rule of law. In line with Article 8 of the Universal Declaration of Human Rights, any person has a right to have their rights restored by the competent domestic courts if the rights enshrined in the constitutions were violated. So I believe access to international law resources actually serves this purpose, the purpose of upholding international law, and it also improves the legitimacy of international arbitration as a way to resolve international disputes. That's all from me. That's all I wanted to say in the beginning. If you have any questions, I will be very happy to take them. Thank you, Dmitro. This was very relevant. I agree with a lot of things that were said. I have a question for you, and then if our audience has questions, we will open the floor for that. The creation of databases of arbitration awards, this is a good cause, of course, being mindful of confidentiality. But I'm interested in your opinion. Maybe one day machines will be able to anticipate the results of the case for lawyers, for the interested parties. Do you think we're going to get there? Well, this is a very interesting, albeit controversial issue. I have an opinion on that. My colleagues agree with me. No, I think that in domestic national cases, in some cases that are not sophisticated, that's probably possible. In complex cases like investment, commercial, sport arbitration, this could be problematic because any case is unique. Every case is unique. Every arbitrator appointed to a case is unique. The circumstances and facts of the case are unique. Well, yes, there could be some smaller disputed amounts in commercial arbitration cases. Nonetheless, I think that this is impossible. What is possible, however, is expediting access to those resources, expediting search of information. However, machines replacing lawyers, I don't think this is possible at this point. Maybe something is going to change, but I don't think so. Well, I agree with you, but in Ukraine we have a database of legal opinions from the Supreme Court, and I recently talked to one of the drafters, Rasimov from the Supreme Court, and he says that very often what he hears from Ukrainian lawyers, what have you done? Nobody's going to need lawyers anymore because people would be able to use keywords to look up the necessary information. I agree with you until, as long as people are resolving disputes, people have to be forming legal opinions.
Please use the microphone. A judge is a human being and not a computer. Yes, basically that's it. If there are any more questions from the audience, I know that we have a live broadcast, YouTube broadcast. Maybe we have some questions on YouTube. Would the audience have any questions, or the panelists? Thank you very much, Dmitro. It was very interesting, a very interesting presentation. Let's proceed to our next speaker. And now I'd like to give the floor to my colleague, Alexey Maslov, who is going to talk about the problem of confidentiality while using new technologies in arbitration. Incidentally, that's what Dmitro has started discussing. Confidentiality is a very relative issue. Good morning, colleagues. I'm Alexey Maslov. I'm the chief lawyer of Evalon law firm. I'm a practicing lawyer in international arbitration. Dmitro, in his interesting presentation, touched upon the issue of this kind of a global conflict between the principles of access to justice, transparency, and development of certain practical framework and base in arbitration, and the principles of arbitration, on the other hand, the principles of confidentiality, And I think that if we look at how it has been resolved before, and what the legal tech, Dmitro's company and ICC have arrived at, now this conflict can be resolved in quite a simple way. By anonymization, by depersonification of the arbitration decisions. What Dmitro said, we used to have it before, and if we look at London Arbitral Tribunal, it has had for quite some time the practice of publishing at least some extracts, or at least some decisions about removal of arbitrators, so that people would know what kind of practice that law has. Our ICAC, it has the practice of publishing some edited decisions, which is quite useful in order to understand the positions of ICAC. And LAN Arbitration Center, they used to have a similar approach. So here, decisions can be found, I think. I think that what a much more interesting issue, and an issue that is now actively faced by the arbitration community, at least following the research I have carried out, is how the issue of confidentiality is affected by new technologies related to non-arbitration, not to the arbitration decisions as such, but the arbitration proceedings. We all know, we have heard, we heard it from Mykola Sullivan, and it's a well-known fact that one can hear at many conferences, how the coronavirus crisis has affected the arbitration. These were the trends that existed before, even before the electronic format replaced the paper flow, and how telephone conferences or video conferences could be used for procedural hearings. After COVID came about, that practice became even more popular, not only for procedural conferences, but for the hearings on the merits. So that advent of technologies was irreversible. And it's quite logical that the arbitration community and clients accepted it quite well, because it's not only convenient, but often it's an issue that minimizes the costs. Well, it's quite a simple thing, like where the documents can be sent by mail. If they can be sent by email, that would be cheaper than on paper. Although again, some new issues arise. E-discovery, for example, whether it is sometimes difficult to analyze databases when they are kept in the client's internal computer systems, but this is not what we're talking about now. I think that in a way the perception of these new technologies was not followed by the understanding of those additional risks for confidentiality that those new technologies bring about. And here it can be illustrated by the research of 2021, the survey of Queen Mary University about the arbitration trends after the COVID pandemic, where the great majority of the respondents said that they already use those new technologies in terms of electronic document exchange and video conferences. The great majority said that they want to keep using it because they believe this trend will continue. However, when the issue of data safety or cyber security arose, whether the data is secured against access to those data by other third parties who have no right of access. Only 1/4 of the respondents said that such issues have been discussed at least in half of the arbitration procedures in which they have participated. And that shows that very often practicing lawyers who represent their parties, the clients, arbitrators, and arbitration institutions, at least until a certain point in time, had not thought about what security measures should be taken so that the use of those technologies would not lead to leaks of confidential information. We all know quite well the examples of how this can backfire, and one of the most high-profile ones is the dispute between China and the Philippines about delineation of sea borders, where there was a leak of information from the database of the arbitration tribunal database. Everyone has heard about that. It was a big reputational hit for that institution, a blow to them. At the same time, I think that recently the trends have been that more and more attention is paid to this problem. This can be seen from the number of best practices in protocols that are developed by various organizations in terms of this problem. And here perhaps special attention should be paid to a cybersecurity protocol drafted by the New York Bar Association together with the International Commercial Arbitration Council, and the IBA also developed such a protocol about cybersecurity. It's very interesting guidelines. They're not simple, they're quite voluminous, but without going into the content of those guidelines, you can read them. Many of you have already done it, I'm sure. I would like to point to the main principle that they all bring up. And the principle is that the issue of cybersecurity is in fact an important issue that is parallel to the obligation of the parties to preserve the confidentiality of information. And this is an issue that the arbitrator and the parties have resolved together, and it's an issue that should be solved on quite an early arbitration stage. So the main principle found in those guidelines is the approach according to which the parties, even before the first procedural conference in a case, before they agree on how their arbitration would take place, they have to establish or try to agree about some common rules of cybersecurity that would be used. For example, in terms of document exchange. Now, at right example, the parties cannot use, for example, the public domain of their emails like Gmail or Ukrnet or Yandex or anything else, but only the servers that are more secure and that are linked to unique domain names of certain companies. It's a simple example, right? But looking at those procedural orders that I have seen in arbitration, I, for example, never saw requirements like that in any of them, although it's quite basic and logical, and it already seriously increases the security of their arbitration exchanged as part of arbitration. The other thing I'd like to bring up about those guidelines, they give an answer. Well, they do not tell you what should be done, what cybersecurity steps should be applied, because it would largely depend on what is the level of the parties and the level of the dispute and the level of the risk that the information exchanged by the parties may represent some serious commercial secret, the leak of which can lead to serious reputational losses and financial losses for the parties. That would depend on what rules are applied. For example, if these are the parties from the EU, then the EU regulations would be applied to them, the cybersecurity regulations. So in those guidelines you will not find the answers as to what should be done, but certain instructions as to the minimum standards of protection and the principle that this should be agreed upon and the arbitrator should think about that at the very beginning. This is what these guidelines have established. Finally, I would like to point to a very interesting latest document, the Protocol of Legal TECO, International Group in International Arbitration, that had some leading law firms that do arbitration as to the use of online platforms. Mr. Sullivan also noted in his speech the online platform that exists as part of the Stockholm arbitration. And it's very interesting to read about that, because that report, in fact, talks about the fact about what will soon become the future of arbitration, about setting up such platforms as part of arbitration institutions that would become the sites for a complete process that can consolidate all the procedural actions of the parties, document exchange of the claims, communication between the parties on procedural issues and hearings, the issues of costs, controlling the costs by the arbitration institutions, communication between all the parties of the process, in one secure site where there would be a proper level of communication security, access to information, and so on. And this is what we already can see to a certain extent in Stockholm arbitration and what many other arbitration institutions are thinking about now. That's why I would really advise you to read this protocol too. It can give you many interesting ideas, food for thought. Thank you very much, Alexei. It's really a very interesting presentation. Tell me please, do you know whether there is any response from the arbitration institutions to those extremely important issues of cybersecurity and information protection? Yes, besides the Stockholm arbitration, and I think that they launched that platform even before coronavirus, and perhaps the greatest motivator for the launch was not so much the cybersecurity, but rather to provide better services to the clients of that institution. However, as regards the latest changes in the regulations, and we know that in the recent years very many regulations, many institutions have been updated. If we look at the regulations, yes, the cybersecurity issue and how it affects the confidentiality of the information becomes more and more important in the regulations. For example, London International Arbitral Tribunal had added a new article in 2020, 30A, which establishes the principle that the arbitral tribunal, in consultation with the parties, should decide whether in terms of information exchange certain measures, cybersecurity measures, should be applied, or information security, as early as possible in the process, ideally during the very first procedural conference. Another example can be the rules of Hong Kong Arbitration Institution, which established that recognized that the parties can use online data storages to exchange information, but those storage facilities have to be secure. They said the rules do not explained what secure means, but that on the one hand, the establishment of the fact, recognition of the fact that the parties can use such storage facilities, and on the other hand, that establishes a certain objective that this information should be secured. Thank you very much. That's extremely important. The cybersecurity in today's world is extremely important. I'm happy to state that we have been joined by our speaker from the United States, Jasmine Lahlou, and she's going to tell us about a ICCA survey. Is there a right in international arbitration to a physical hearing? That's what you have just mentioned, and that's a very interesting question. Welcome, Yasmin.
Good morning, everyone. Can you hear me okay?
Yes.
Perfect. It's very nice to join you. I wish I was able to join you in person, but until then, I join you from my apartment in New York City. I am here to tell you about a survey that you should be able to see my screen. Can you see them?
No, I don't think we see
All
it.
right, perfect. So, all right. So this is a survey that we conducted
We can see it now.
with two of my colleagues, my partner James Hosking at my firm, and Professor Giacomo Corselchetta from Roma Tech. And we launched this project with the International Council for Commercial Arbitration, ICA, to determine if there's a right to a physical hearing in international arbitration. And we received contribution from 77 reporters from New York Convention jurisdictions who addressed a series of 10 questions about whether there is a right to a physical hearing. The questions were about what Lex Arbitri has to say on the issue, until what the courts have had to say on the issue when they are asked to enforce a foreign award under the New York Convention. This is sort of the overview of what I will be speaking about this morning. And I'm sort of going to give you a bird's eye view of the results of the survey. The survey has been completed in June of this year. We published sort of in vagues of reports starting in December, then March, April, and then June, the last few reports. And what has been fascinating is what we have seen, a level of convergence between the Lex Arbitri of most New York City jurisdictions, which is a result of huge efforts of modernization and the related adoption of the unusual model. To the opening question of the survey on whether a right to a physical hearing is expressly recognized or can be implied from either the Lex Arbitri or the rules of civil procedure, in the vast majority of the country, there is no express right to a physical hearing. In the last two installments, none of the surveyed jurisdictions contains any express provision granting a right to a physical hearing. And what I should have said earlier is that if you go on the website of the International Council for Commercial Arbitration and you look for, and there is a link for whether the survey that we conducted, you will land on a page where you will have free access to the various reports that we have prepared with the reporters. And so if you look at them, you'll see that the most recent installment showed that the Lex Arbitri and contains no express provision granting a right to physical hearing. However, for example, in the Netherlands, that jurisdiction stands out as the first jurisdiction surveyed where the lex arbitri expressly provides for the possibility of conducting remote hearings subject to certain fundamental procedural safeguards. Conversely, there is a small group of jurisdictions where the right to a physical hearing may be inferred by way of interpretation, and that includes, for example, Ecuador and Germany, where they suggest that such a right can be inferred by way of interpretation, drawing from the principles of civil procedures, and in Ecuador for the Ecuador's constitutional guarantees. In Sweden, our reporters took a strong position, which is contested by many other Swedish commentators, that the right to a physical hearing must be inferred from Swedish law, drawing from principles of domestic procedural law. We should take the content of that report with a bit of a grain of salt, because the authors of the report are also parties to a pending challenge they brought against an award before the Swedish highest court, challenging the award on the basis of a violation of a right to a physical hearing. So we must be also mindful that authors, specialists of arbitration in Sweden contest that position. A right to a physical hearing is also recognized in Venezuela, although limited to the first hearing, which must be held physically, or at least not fully remotely. In some jurisdictions like Benin, Norway, and Tunisia, where the right to physical hearing can be inferred, must remain unclear, and very often this is primarily the result of how much role should be given to the rules of domestic procedure, because often if you look at the rules of civil procedure that apply to domestic proceedings, you may infer such right, and the question is, do you extend such right to arbitration? And also, like for Ecuador, you can look at the constitution to certain guarantees provided for due process, which often imply right to physical hearing, apparently, and whether these constitutional guarantees can extend to arbitration and, by extension, to international arbitration. In Germany, our reporters have indicated that the right to physical hearing must be inferred from the rules of civil procedure. By contrast, the role oral was expressly removed from the corresponding provisions of the Bulgarian lex arbitri, which confirms implicitly, according to the authors, that the right to a physical hearing can be excluded. In general, many statutes or laws expressly assign to the arbitrators the discretion to hold remote hearings, such as in the UAE, including Abu Dhabi global market. And as I was referring earlier, there is the relevance of the model law and Article 24 that you see quoted on the screen here, which provides that the tribunal shall hold an oral hearing if a party so requests. And whether the right to request an oral hearing translating to the right to request a physical one is once again excluded by most model law jurisdictions. I mentioned, for example, Argentina, Croatia, Dominican Republic, Iran, Ireland, Jamaica, Japan, and so on and so forth. But for example, in Zimbabwe, the right to an oral hearing is arguably a right to a physical hearing, considering the practical difficulties of conducting remote hearings due to unreliable power and poor internet connections. In Norway, we cannot reach really conclusive answers, according to the authors. Based on domestic practice and the rules of civil procedures, some scholars argue for extension of the right to a physical hearing to arbitration as well. But on the other hand, if the Norwegian lex arbitri is interpreted in light of the international legal sources upon which it is built, one can reach the opposite answer. And interestingly, the problem is non-existent in Thailand, where the wording of the corresponding provision of the Lex Arbitri has been amended in such a way as to rule out the party's right to request a hearing at all. And in non-model law jurisdiction, the position in Switzerland sort of stands out because the right to an oral hearing is excluded altogether, just like in Thailand. Even when the parties have chosen arbitration rules expressly recognizing such right, or when the right to examine witnesses orally is provided in the terms of reference. And in China, by contrast, a right to a physical hearing is recognized in litigation, and it cannot be totally excluded, although it is unlikely, according to the authors, that such right would extend to arbitration. What the reports show as level of conversions as well is sort of the very broad level of conversions recognizing a broad discretion to the arbitrators to make decisions on the conduct of the procedure of the arbitration. And so this is limited by the requirement right to present their case. And I will just note a few jurisdictions such as France. The parties can require the tribunal to conduct a physical hearing if they both agree that there should be a physical hearing. That said, for example, in Portugal and France, if they agree to that after appointment of the tribunal may disregard that conclusion, that agreement. You will see also, if you look at the report, there is divergence on the interpretation of the New York Convention on what law applies to the issue, whether on whether you should vacate an award on the basis that right to physical hearing. Which law do you look at? The law of the forum, does it require physical hearing? Or do you look at the law of the seat of the law that applies to the arbitration agreement?
Excuse me, Yasmin, I'm sorry, excuse me.
Just violation of the right is sufficient for enforcement of the foreign. I think I will conclude now and see if there are any questions.
Yasmin, unfortunately, the connection is not good at all, and we can't hear you. We can't hear you well. Can you please? We have 2 or 3 more minutes. We're a bit limited in time, so if you can. Oh, sorry. If you can finish your presentation within a couple of minutes, that would be fine, because we can't hear you well, and we will forward the questions regarding this survey to Yulia Chernik, who is with us today. Huh? The representative of Ukraine in this survey. Она слышит нас.
Доброго дня, колеги. Мабуть,
Good morning, dear colleagues. Probably the internet is bringing these bad surprises, but I had an opportunity to participate in this survey, and I would like to say a few words because the project is truly very important. It opens a lot of questions. Is there a right to virtual hearings, and is there a right or an obligation to have offline physical hearings? This project was organized jointly with International Council of Commercial Arbitration. This is an NGO, well respected, that has existed for 60 years now. It is known for their very interesting publications and development of standards in the area of international arbitration. The national experts from various countries were asked questions about whether their countries have an obligation to have physical hearings, not online hearings, but physical hearings. Oral hearings necessarily physical hearings, or can we step away from that? What are the rules of those hearings? Is there practices of overturning decisions, etc.? And experts from 86 countries provided their answers. All of those answers are published at ICA website, so you can go there and check 86 reports. How in various countries those issues were regulated. I can share my impressions because we are expecting the summary report in which the organizers of the research are going to provide the assessment and comparison. And Yasmin was trying in her report, which was prevented by some technical problems, she was trying in her presentation to speak about various observations about differences in regulation. And my observations are, I was surprised to learn that the states that have domestic legislation based on the model law, the so-called model states, they use the same provisions in a different way. Ukraine has domestic legislation based on UNCITRAL model law, and there's right to oral hearings. However, what is implied by oral hearings, in some countries, it turns out that it happens in a different way. So if we see the same provision, or if we believe that we are part of the same model law, it doesn't mean that the very same model law provision is going to be applied in the same way. Another thing that was not a big surprise but was very interesting to observe in some jurisdiction, and the project took place in 2020. In some jurisdiction there was already some jurisprudence about overturning, recognizing, and some jurisdictions did not have that. So you have to understand that there were 3 waves of submitting a response from the experts. It was in May 2020 in particular. So you have to understand that we have more understanding and jurisprudence. But what's interesting, some jurisdiction gave a more profound picture because they had more jurisprudence. And the third observation, the reports provide very interesting observation. Because the topic of our event is evolution of arbitration. The experts were asked to share what changes took place in national regulation framework. Maybe there were amendments to arbitration rules. And with regards to Ukraine, it was very pleasant to see that there was something to write about. ICAC amended the arbitration rules, allowing arbitrators which could have been interpreted from previous rules, but they wrote that arbitrators could decide on the format of hearings, virtual, offline, physical, or hybrid hearing. And last but not least, I would like to say that all of the experts were unanimous in their opinion. These reports showed various types of regulation, but all of the experts were unanimous that if virtual hearings are conducted, then the basic principle of arbitration remain unchanged. The parties have to be provided with an opportunity to prove their case. There has to be equal, fair treatment of parties. So this was a very interesting project. It's not yet over. We are still waiting for this summary report about all of the jurisdictions. But even now, you can read about the jurisdictions you're interested in. There are 86 countries, so quite a selection. No microphone is used. What are the trends? Is there right to physical hearing? What are the preliminary conclusions? Well, I can share my observations. Well, based on the reports I've read so far, the general trend is to recognize the right to virtual hearing if a party requests that, but even if the parties do not request that, the arbitrators, given the pandemics, can decide in favor of the virtual hearing if the parties can attend, because there are some situations when some valid circumstances preventing the parties from participating. In our case, it's not so much about the rights of the parties, but the obligation of the arbitration tribunal, not virtually, but physically, to come and to hear a case. That's what it is about. That's as far as arbitrators are concerned. So the parties request to have a hearing not in the United States or Norway, but in ICAC or in other buildings, so that they could directly have this oral hearing. This is where the differences arise in the reports. This project is called the right to virtual hearings, but actually it is about the right to physical hearings. So the key question that the experts were asked, whether it's the party's right to request physical hearings and whether oral hearings have this element of physical hearing or not, or oral hearings can be virtual. And this is where the differences arise. And the way I interpret the reports, this right to virtual hearings includes right to oral hearings. So if we say that there have to be oral hearings and virtual hearings, there's no infringement there, but there are jurisdictions in which the understanding of what is an oral hearing implies that the party can request physical hearing. The distinctions between the jurisdictions in the report, that's not something I can reply about at this point. I didn't review all of these 86 jurisdictions. We shall wait for this presentation. It will be presented at ICA Congress, and we'll see the distinctions between countries in this matter. Thank you, dear colleagues. Thank you, Yulia. You saved the topic. We don't have much time left in our session. I would like to hand it over to Ms. Ksenia Kurikalova. She will be talking about evidence and proof in virtual hearings. Ksenia, over to you. Thank you, Aminat. My name is Ksenia Kurikalova. I am Senior Associate of Aqua Law Firm. So let's talk about evidence and proof in virtual hearings. It goes without saying that the trend to have arbitration hearings online, or at least partially online, has been around for a long time with the development of technologies in particular, but the COVID pandemic raised this issue again, and the community had to adjust to the new reality. And in recent years, 2020, 2021, we saw a wave of changes to arbitration rules of key arbitration institutes throughout the world, responding to these new challenges. These were amendments regulating hearings online, in particular submission, examination of evidence of virtual hearings. What should be noted is that ICAC is well aligned with other arbitration institutions. At the end of 2020, as we know, there were most recent amendments made to the arbitration rules of ICAC, and these amendments directly regulate the right of the arbitrators to have parties participate in the hearing through video conference from outside ICAC, and there are rights of the parties to move to allow for online participation in the hearings, and it was specified, and in such a case, a party shall partake in the hearing using their equipment, digital signature, or other means that arbitration court shall deem applicable. But there's one aspect here. There are risks with connectivity, technical problems. These risks are vested in the party that moved to participate in the hearing online.
We still have the provision that says that it is possible to hear experts and witnesses in video conference, as Mr. Sullivan correctly said. We had the provision in the previous regulations as well. And from my own experience, I can tell you, when I participate as a lawyer representing a party, even before the latest changes in the regulations, that provision had really functioned well. We had cases where the witnesses would be heard in video conferencing, and I have participated in a case that was quite complicated. There was a need to have several hearings on the merit and to interview one of the key witnesses. That interview lasted more than during one hearings, and if I remember it correctly, in one of the hearings the witness was physically present while to interview the witness. In the other hearings where there was a need for it, the decision was made by the client to request that they be heard in video conference, and that was equally effective, not less effective as it would have been in live communication. The witness was interviewed, the witness provided testimonies on everything that we needed. At the same time, the client and the witness saved their time and money, and the balance between the costs and the result was preserved properly. Changes have also been introduced to other instruments, in particular to the rules of the International IBA Association, International Bar Association, to get evidence in international arbitration. And as Alexei Maslov correctly said in his presentation, an important issue that the new version of those rules focuses on is that the parties and the arbitrator have to agree upon all the main issues as early as possible in the process related to the use of technologies, with participation, online participation, and in addition to cybersecurity and confidentiality issues that have already been presented quite profoundly, they are also talking about some practical aspects and nuances to which attention should be paid in this somewhat new format of considering cases with the help of technical means. First and foremost, the arbitrators and the parties need to agree as to which equipment they would use. Would that be submission of documents, exchange of the documents, the merits, providing evidence via certain platforms? How would the oral hearings take place, with the help of what technologies? Another important issue is how to confirm the authenticity of electronic copies of written evidence and electronic evidence. Quite a lot of institutions are already paying attention to this issue in their regulations, and ICAC is not an exception. In Article 52, it suggests certain provisions about the confirmation of the authenticity of electronic copies. What is also important, an important issue that arises in practical terms as well, is participation of the witnesses and experts and interviewing them online. Perhaps one of the most evident but very important aspects of it is the fact that now in our globalized world, the witnesses and experts, the parties, the arbitrators can find themselves in absolutely different parts of the world or different areas. Sometimes there may be quite complicated situations where, as a result of the fact that the parties, the experts, and the witnesses find themselves in different time zones, the hearing would take place in some substandard times. Well, we're all lawyers. We all work to meet the interests of our clients as much as possible. And of course, the arbitrators, they also participate in arbitration proceedings at the time that takes into account the existence of different time zones, but this issue is to be discussed and given special care too. Another important issue that often arises within the context of online virtual hearings is possible abuse, possible improper influence on the witnesses or experts. In the traditional format, where an expert is interviewed or when an invited witness testifies during arbitration proceedings, we can all see that person. This person answers the questions by himself or herself. There is nobody influencing that person, forcing him or her to give certain answers. That's quite evident. At the same time, when we can only see a person on the screen of our computer, there questions arise as to what one should ensure compliance with all proper rules, such as ethical rules, as well as how one can make sure that there is no improper influence upon that person. And these are also the issues that need to be discussed. So the witnesses and the experts, and of course representatives of the parties, they have to be made aware of the rules that would be used, and the witnesses and the experts should of course agree to those rules being applied. So as even current practice shows us in terms of hearing virtual hearings, this is what we have had in the course of the past year or two. All these issues, they really arise, they really need to be regulated, and the quicker the parties and the arbitrators discuss them and establish certain rules and comply with them, the better the results would be that all the users expect from the arbitration proceedings. I would like to wish all the participants of the arbitration proceedings so that those issues be regulated as fast as possible. We now have more and more resources that can be used in order to establish those rules and comply with them as best as possible. Thank you very much, Ksenia. Tell us, please, it was very interesting when you shared your own experience of conducting such cases. From your experience, how was the process of arbitration hearings adapted, in particular in ICAC, under the Ukrainian ICC and other arbitration institutions recently? What can you note here? Well, first of all, I would focus on the experience of ICAC. I think that the process has become more comfortable. We see more possibilities to interview the witnesses online, and that provision that was established in the latest amendments to the regulations, that for the arbitrators it's also possible to participate online. It's just really convenient. At least from my own experience, this does not have any negative effect on the quality of hearing. And well, of course, we are not secured against some technical problems. However, they can be prevented by using proper equipment, by testing it beforehand, etc. We all basically, both in the arbitration environment and the business environment, in the recent years we have all become used to the idea that one can work online when it is necessary. Well, of course, personal communication and the benefits of personal communication stay. They stay are very important, but as a possibility to balance different interests, that's very good, and it should further develop. There is a question? Go ahead, please. Microphone, please. Good afternoon. It's probably not so much a question, but a brief comment. I think it's very important to understand that all the parties to online hearings, I mean representatives of the parties, the arbitrators, they also have to work a lot to understand it, because we're losing such a very important possibility as to see the psychosomatic reactions of the other party or of the witnesses. I also have some experience, and I see that even the defense counsels, the lawyers, would not monitor, would not be able to watch this behavior during the online interviews. And as regards the arbitrators, they would also sometimes have questions as to whether two arbitrators, for example, can work offline while the third arbitrator would work online. Not all the arbitrators would agree to that, because, for example, psychologically, on an individual basis, a person may believe that those two other arbitrators who stay together, they have better communication possibilities, so that they can kind of have some joint emotions when the arbitrators are staying together. That's why I believe that this road toward understanding of online hearings is only just starting, and we will yet have to learn many things, because among other things, we also have such an important situation where, for example, we may have people with a different command of languages, with different psychological possibilities of how they can present their even present their IDs. I'm talking about the witnesses, even in the internet or on TV or in real life. There are many questions, and these are questions to the lawyers as well. Even if this is a very good witness, but if one cannot either technologically or emotionally affect the arbitrators, then we may have a question. We can lose this case online, although we could have won it in real life. No, what I'm saying is that I support, as the speaker just said very correctly, that there are very many things to learn yet, and that means we have to work with ourselves quite diligently. And even when we're saying that it's very good that we have such formats now, it's good, really, but in order to be able to use it, at least 50%, we all have to work on it yet to learn our lessons. You know, that's like an iPhone. It's a good thing, but you have to learn how to use it. And I think that's really true, because you're absolutely right. A person can suddenly be at a loss standing in front of a camera. It's one thing when you're looking somebody eye to eye, another thing we're looking into the camera objective. I would add a little bit to it in terms of the use of technologies. An important thing here is the issue of accessibility and access of the experts to arbitration proceedings, because I think that online technologies and virtual hearings give many possibilities to smaller firms, not only to firms from the key arbitration jurisdictions for participation. I think that there is a good potential in it to broaden this arbitration club, at least for such large arbitration cases. And the other thing, to defend the technology. Zoom has not been developed or designed for video hearings, for example. I completely agree that there are many technical issues that we do not really understand how they work. Like, for example, how can you keep an eye contact with a witness or an expert during the interview, because people do not know whether they should be looking at the screen or at the camera and watch several windows at the monitor at the same time. But I think that if certain efforts are made and some kind of app is developed that would be designed specifically for arbitration hearings, we could get some interesting solutions, like some virtual rooms, for example, and the use of virtual reality instruments for our hearings. So I would not exclude it in the future. It's a good idea for a startup. Yes, Yulia, please. I have a question to Alexei, but it would be interesting to hear Aminat and Ksenia about that. I think that online platforms for arbitration institutions are not the future anymore. This is the nowadays. What interests me more is the arbitration institutions are not technological companies. They are not like we used to have a speaker from US Mundi creating those platforms by ourselves, and how we can update them, how can we keep them modern so that the technologies that are proposed to the users of the services would meet the current standards. So shall we cooperate like with Stockholm Institute does it with Thomson Reuters? What is the future of that? What do you think? Should there be any effective cooperation, or should the institutions develop? We already are used to the idea of having PR and marketing units at those institutions. Would those challenges transform the role and the value and the role of the arbitration institutions? Colleagues, a couple of words each. Briefly, let me start. I absolutely agree that this is a reality today already. It's evident for me that the arbitration institutions, as the institutions that do not have technical expertise, they cannot do it by themselves. Hire one or two or three IT experts and tell them to create a platform. There should be cooperation, like legal tech cooperation with large technological companies or small startups that specialize in those issues. As to the future, that's a very interesting question, in fact. And there are many options. There can be a parallel development of competing proposals with other arbitration institutions. Some of them already have it, and that gives a push to the others to create such solutions as well, especially if the users like it. There can be an option for cooperation, but then a question of cooperation between whom? Of what institutions? Wouldn't they lead to a club of large arbitration institutions who would create jointly some ideal platform that would become a new word in arbitration proceedings, and those arbitration institution clubs that will not have this app and will not have the money to develop it, because I can imagine that this is quite a costly toy that not every arbitration institutions can afford. That's why it's just like with large technological companies like Facebook, there's always a risk of monopolization. And it's a global issue of risks that technologies bring into our world, including into our profession. I think that that's a very good niche. Most probably in the nearest future, technological companies will understand that. Perhaps we'll start filling this niche. How will that happen in real life? Only time will show. It would be very interesting to watch the developments. Thank you, colleagues. At the moment, that would be all for our first session. We really don't have any time. The organizers really... Let's discuss all these things in the wings. Or maybe at the end of our hearings, we'll get back to some of those issues. Thank you very much.
Ну що ж, шановні колеги, дорогі друзі, раді щиро ще раз вас вітати. Ми продовжуємо нашу наступну сесію, яка називається «Розвиватися і рости. Розширення арбітрабільності спорів. Які перспективи в Україні». В першій сесії ми багато почули про те, які є сучасні тенденції, особливо ті, що стосуються такого ковідного.
Given the COVID pandemic, we can assume that probably life will never be the same, and more people will be willing to have online hearings. More and more lawyers will not be able to be physically present. But we'll see. During our session, we will be discussing insolvency, corporate disputes, investment disputes, and Ukraine as seat of arbitration, and the issues to be discussed are quite practical and quite controversial. Insolvency and bankruptcy in trans-border cases, corporate disputes, these are standalone immense issues that can take up to dozens of volumes of documents to describe. I can write a book on history of corporate disputes in Ukraine. I don't know if there would be anyone to be interested in that, but everything's evolving. And Mr. Sullivan said that we keep reforming things, and there's going to be reforming that as well. So this is what we are going to be talking about, and it's such a pleasure to see esteemed participants. We have Artem, who came to Ukraine. So thank you for that. And with that, I would like to hand it over to Sergei Ryshko, partner at Redcliffe Partners, who will be speaking about insolvency. Thank you. Could you please put my presentation on the screen? Aside from being partner in Redcliffe Partners, I'm also an arbitrator in ICAC at Ukrainian Chamber of Commerce and Industry. The topic of my presentation is what you can see on the screen. First, we will be discussing the nature of insolvency itself, and then we'll try to understand how all of that combines with arbitration. First of all, it needs to be mentioned the procedure of bankruptcy, as according to our Supreme Court, it is about public and private interest. Public interest protection is reflected in prevention of fictitious bankruptcy, and also pushing a person into bankruptcy. The protection of private interest is the satisfaction of creditors' requests, restoring solvency of debtor, or liquidation and selling of the property in liquidation procedure with the purpose of meeting the demands of the creditors. One of the key functions of commercial court during the proceeding in bankruptcy cases is striking a balance of interest while protecting public and private interest. This is very important, which sets the standards for interaction between arbitration and insolvency. Regarding legal framework, there are a few provisions in our legislation that directly regulate the matter, in particular the law on international commercial arbitration, in terms of recognizing, enforcement, and overturning of decisions, and Commercial Code of Ukraine that specifies that the disputes under jurisdiction of commercial court can be referred to arbitration, with the exception of bankruptcy cases and cases with damages claims, in particular with disputes to declare void certain deeds, salary cases, and debt assignation before the initiation of the bankruptcy case. So let's look at how the matter was regulated in the practices of our international colleagues. There's a very interesting case, Vivendi Universal versus Electrum SA, a French company versus a Polish company. The dispute was about property rights to the shares of telecommunications company, PTC company, which is a Polish company as well. In August 2003, Vivendi initiated arbitration case with LCIA about Electrum, infringed on the third investment agreement, in line with which Vivendi was expected to receive a share in PTC. In April 2006, Vivendi initiated arbitration case with ICC on infringement by Electrum of reconciliation agreement dated March 2006. On the 21st of August 2007, based on the claim from Electrum, the Warsaw Court ruled issued a ruling on Electrum's bankruptcy, and the management of Electrum maintained control over the assets and activities of Electrum. On the 22nd of August 27, the LCIA arbitration panel was informed, and in September, ICIA arbitration court was informed. In February 2008, Warsaw Court revoked the corporate management of Electrum. Electrum state that LCIA and ICC both do not have prejudicial powers in line with Polish law on bankruptcy and reorganization, which had the following clause. Any arbitration clause entered into by a bankrupt loses legal force as of the date of declaration of bankruptcy, and any bankruptcy proceedings have to be suspended. This is quite clear. In March 2008, there was a partial LCIA arbitration award, in line with which the Polish court rulings are regulated by English law, and the composition of the arbitration panel has the jurisdiction over that. In 2008, in July, there was a partial decision in Geneva, in line with which the bankruptcy regulations regulated by the Polish legislation, and there's no jurisdiction for the arbitration. In August, High Court of England left ICIA's decision in force, and Federal Court of Switzerland later remained and changed the ICIA decision. So everybody was right. Let's continue. Stay tuned. Okay. The English case. In line with European regulation on insolvency proceedings, the law that is used in bankruptcy case is applied to defining the impact of such proceedings on the current contracts in which the debtor is a party, and impact on the proceedings initiated by certain creditors, with the exception of the claims that are pending, lawsuits pending. Next. The proceedings is regulated by the country in which the proceeding is pending. Arbitration proceeding is the claim lawsuit pending, and since Electrum was engaged in arbitration proceeding in London before the bankruptcy proceeding in Poland, law of the seat defines the impact of bankruptcy procedure and arbitration. So legal competency of the country is regulated by where the company is registered. So Polish bankruptcy legislation has to be applied. Article 142 that we mentioned before. So when Electrum declared bankruptcy, any clauses were no longer applicable, and arbitration proceedings have to be suspended. Switzerland is not part of the EU, no longer Britain either, but it was still part of the EU at the time. Later, Federal Supreme Court decided to step away from this approach and decided that arbitration agreement, in line with Article 178 of the law of Switzerland on international private law, remains applicable despite the fact of the bankruptcy. That was in a different case. I can see I don't have much time left. Well, I have a question about Ukraine. Well, we're getting closer to Ukraine. Unfortunately, I cannot see what you see. Is this what you see? Okay, I'm just seeing a blue screen. This brings us back to the issue of online hearings. In line with the summary of jurisprudence of challenging ICAC cases, bankruptcy cases, there was a summary from the Supreme Court of 2015, that asking the court so if the debtor with arbitration award is in the procedure of bankruptcy, this is not a prevention to reject the international arbitration case. Based on your experience, when you have a client and when you realize the client is about to go bankrupt, but there's arbitration clause, so what do? Bankruptcy or arbitration? So let me finish. I have a few more slides left. And then I'll take this question. There's an answer somewhere there. Okay. Civil Court of the Supreme Court. They also sustained the same opinion that bankruptcy case do not imply denial of arbitration award enforcement. But I had a different question. The recent case that I would like to discuss is Cassation Commercial Court at the Supreme Court. From this court, the creditor initially went to court that heard a bankruptcy case of the debtor. The creditor's claims to be declared a creditor were not granted. Arbitration proceeding went on simultaneously. He won the case in arbitration. Then he took a case to Ukrainian court to get an enforcement order. He received that. He took it to the commercial court, and the commercial court did not grant his request to be declared creditor. Well, as the clients say, we know you know a lot about court cases, but what do we do in our case? Well, let me say here that there's a risk to not having a leave of court to enforcement of international arbitration, as the support plan has indicated. So if I have a client, let's imagine the situation. The sooner they initiate an arbitration proceeding against a debtor that is about to initiate bankruptcy proceeding, the better. And then this decision needs to be recognized. And then you'll take your place in the line of creditors. Thank you, Mr. Sullivan. The issue that Sergei raised is very relevant. He mentioned something that is very significant to us. Whether the courts will be perceptive to the arbitration awards if the party is in bankruptcy proceedings. And I have another relevant issue. What do you do with the arbitration case if a party to the proceeding is not yet in bankruptcy proceedings and the arbitration case is initiated, and in the process of arbitration this bankruptcy manager, and no matter whether that's Belarus or Switzerland, Czech Republic, bankruptcy regulations are give or take the same for all countries. Second point, if the claimant comes to court and it becomes known that the other party is in bankruptcy proceedings, so what do you do then? Do you initiate a case or not? Or do you wait till the liquidation commission finishes doing their job, or when the sanation is complete? We have 5% of those cases. Yesterday, I signed a ruling on suspension of a proceeding. I haven't read the Swiss ICC decision, but my reasoning was similar to ICC's. What the problem is, there are two theoretical questions. So what happens with the arbitration clause when one of the parties is going through bankruptcy proceedings? Fortunately, ICAC has all-standing tradition. First of all, you have to check at what stage the proceeding is. Proceedings might last for years. Secondly, there's no way knowing what the proceeding is going to end, sanation or liquidation. So if it's so there are cases when we can continue arbitration proceeding if the case is opened. Then it's the case of bankruptcy proceeding initiated before arbitration or after. Second, we apply lex arbitri, and we apply substantive and procedural law, Ukrainian law. And the question, do we need to give consideration to the debtors' domestic legislation? So I would say, why would we need to do that? We need to issue an arbitration award, and that's it. Because we can do it. There's arbitration clause, lex arbitri is Ukraine, and I think this is short-sighted because at the end of the day, we need to make sure that arbitration award is enforced. And if you look at Belarus, for example, arbitration institution needs to know if they issue an award and it runs contrary to Belarus bankruptcy regulations, then it renders it unenforceable. It's void virtually, because Belarus court will declare our decision as contrary to their domestic legislation, and we have to remember about that. So in my opinion, this is quite a sophisticated matter. Thank you, Sergei, for raising that. And this is something that Yulia Chernych was talking about. She mentioned that ICC had a similar case.
One more thing. In the Ukrainian bankruptcy laws, they say that there may be a situation where all the proceedings should stop. Now, according to our bankruptcy code, there is no such imperative provision. So theoretically, we can continue arbitration proceedings, remembering that there is a moratorium and that everything can only the claims can only be issued by the state, by the public court in the process of bankruptcy proceedings. So a priori, our decisions cannot be executed, even if we issue them. So he has studied the case law, and he found that even our arbitration decisions would not be recognized by commercial courts as evidence, as proof of the fact that the bankrupt has some kind of obligations to the creditors, by referring to the fact that all the legal facts that have been studied by the arbitration court or arbitral tribunal would not be taken into account by the public court, by the state court, and would have to be studied from scratch. Incidentally, a working group of ICAC has developed a revolutionary draft where we're trying to revoke that provision. I don't know whether we will succeed, but that proposal is on the table. So I would like us to continue this discussion, and well, I haven't taken your time. I am the organizer, that's why I am giving you 5 minutes now. But it's a painful issue, not just for us, but such grants and ICC and CI have made the opposite decisions. A very short comment. Well, we should not forget that we used to have a case in our company when there was an arbitration award of CAC against the company in the energy area that has been in their bankruptcy for the past 25 years and is not going either here or there. And we have to understand that that decision was suspended. We have received a judgment of the European Court of Human Rights that that was a violation of Article 6. Such decisions of the commercial court, we have to understand that the creditors, they also have their rights, and when the arbitration decision is not recognized, or when the clients are not given a chance to collect compensation in arbitration, that's violation of the creditor's rights. And if the national courts support that, then this is the place where, well, in our countries, the countries of the Council of Europe, where the European Convention of Human Rights meet with alternative dispute resolution. So I believe that that's a 100% case for Strasbourg. And if the commercial courts do not want to use those requirements, then our country will have to pay the damages to such a client, because the European Court will find violation of Article 6 of the European Convention. I am sure that a decision should be made. As long as there is the legal person of the debtor, and execution of a judgment is not an issue for the arbitration, it's an issue for the country. I'm sorry, Mr. Sullivan is not using the microphone. No, if you give such a creditor a chance to get a decision, to take broad this decision for execution, and the creditor would be rejected, then if this is a country of the Council of Europe, then one will be able to give this case to the European Court. Okay, we have taken 10 minutes that you have presented to us, Mr. Sullivan. Okay, 7 minutes. I did not express any position myself, but together with Oksana, we wrote a whole article about that in the arbitration newsletter, where we talked about bankruptcy more from a lawyer's point of view, and we came to the position that according to the Ukrainian legislation, one can take two roads, either for arbitration or for bankruptcy. We as arbitration lawyers, we're talking about the principle of the free choice of the party. If a party can go both to arbitration and bankruptcy, why don't they go there? Yes, bankruptcy can last for 25 years, and there can be more and more other decisions. I, as a lawyer, would say, let's take both roads, and then we will see. There will be no double forfeit or double collection, so there are no risks, in fact. Okay, we've started discussing bankruptcy. Usually lawyers and business people say that bankruptcy is the end, while bankruptcy lawyers, they usually say that that's just the beginning. But for now, we will suspend the bankruptcy subject. If we want to get back to it, we will. Now, arbitrability and corporate disputes. I think that among those present here, well, I know who has not written in one's articles about the arbitrability of disputes in Ukraine. I think we have all done it. We can write a whole book on the arbitrability of disputes in Ukraine. I think most of you know that at the Verkhovna Rada there is a draft law number 5357 about improving the work of arbitration. Improving usually means something that would not really improve the situation. And there everything comes down to two simple things. Allegedly broadening arbitrability, although there are many discussions about whether this is broadening or not, primarily in terms of public procurement, in terms of privatization related disputes, and very indirectly corporate disputes, where we're saying that we are now excluding from that provision the idea that all the parties should sign the arbitration clause, although we all understand that how can we bring a party to arbitration if one is against the arbitration clause and there is no contract. So we have this draft law, and the other important block is about the possibility to establish arbitration in Ukraine. And I think that here we can clearly remember the situation with arbitral courts. We used to have 450 of them. We remember all very well how this ended up, and we all remember that we can create possibilities to have one's cases decided abroad, as now every garage can have one's own international court of arbitration. So now we will export such cases for execution or for hearing abroad. So it's a very difficult draft law, and I want to call upon all of you to provide your comments. It's a draft law introduced by the Cabinet of Ministers. We understand it's quite an important governmental bill, and it's important that they listen, give heed to us, the arbitration community. We will narrow it down, our today's discussion, to corporate disputes. I'm inviting Artem Grishko. Artem said that he does not speak Ukrainian. That's why we will ask him to use Russian. Well, Russian would be better for you. I think that it would probably be easier if you speak Russian. Thank you very much, Markian. Thank you. Good afternoon, everybody. I'm very happy to participate in this live event, especially in another country. So thank you very much for having invited me. And I hope that this is a sign of the fact that things are getting back to what we were used to before. I am Artyom Dudko. I come from London. I'm a partner of Osborne & Clark law firm, and there I deal with arbitration disputes. I was asked to briefly talk about arbitrability of corporate disputes according to English law. Frankly, we do not discuss the subject in London very often. For us, this is not a subject, in fact. Why? Let me try to briefly explain. Well, first of all, in the English law, there is no statement about arbitrability of disputes. That's in the general and talking specifically about corporate disputes. Besides the main law, which deals with arbitration, this is Arbitration Law of 1996, does not contain any limitations or restrictions in terms of arbitration, especially in terms of arbitration related to corporate disputes. In fact, Article 1b, one of the main general articles of the law, says that the parties are free to agree upon how to resolve their disputes, except for the issues where public interests are concerned. And that's perhaps the main interest that my presentation is going to come back to all the time, because this is the main limitation that we have to bear in mind while making our decision whether a dispute is arbitrable or not. When we discussed the issue about arbitrability of corporate disputes some time ago, a decision was suggested that the issue of arbitrability is not a dispute related to the commercial world, but some exceptions would probably go outside of this commercial world. Next slide. So, according to the standard rules of arbitration, according to the English law, there may be some kind of limitations that can cover, in exceptional cases, cover corporate disputes. These are quite standard provisions, that is, the absence of an arbitration agreement, that's the absence of the jurisdiction of the arbitrators to award the remedies that the party is seeking, and some other public policy exceptions. Now, as to the arbitration agreement, well, as is clear to everyone, the jurisdiction of the arbitrators is limited by reference to the arbitration agreement between the parties. So if we're talking about corporate disputes, so where this arbitration agreement will be, probably in a shareholders agreement or some kind of a joint venture agreement, joint business, or perhaps a corporate statutory document, what we call articles of association in England. Theoretically, it is possible to write down that there would be an arbitration clause in it. So if we are talking about those people who have agreed to resolve certain disputes between them in arbitration, that's arbitrable, even if it is corporate disputes. But if it touches the interests of some third parties, there may be an arbitration agreement between the shareholders, but not between all the shareholders. And there is a dispute that concerns the interests of those shareholders who have not signed this agreement. So this dispute would not be arbitrable. Or, for example, there is a dispute that concerns the interests of the creditors of the company, like the bankruptcy process. For example, external creditors that are not related to the company, that have not agreed to bringing the case in arbitration. So once again, this dispute would not be arbitrable, or at least those issues that concern those creditors would not be arbitrable. The available remedies that an arbitrator can issue. Well, once again, this limit to the standard procedures or rules of the English law. So an tribunal may not order certain remedies that the party may seek in a corporate dispute against the third parties, or if there are no relevant provisions in a specific arbitration agreement. And the general limitation of a public nature, again, getting back to what I've already said several times, the parties can decide which disputes would be resolved and how they would be resolved in arbitration. As regards corporate disputes, potentially limitations can be related to the rights of the staff, of the employees, where, for example, an employee may have a right to file one's claims with a tribunal dealing with employment issues or some issues of criminal liability. Although what's interesting, the arbitration process can hear issues related to criminal law. For example, quite often in corporate disputes that can be treated in arbitration, there may be questions about issues related to bribes. This is related to criminal law. Still, the tribunal and the arbitrators can decide upon such issues. The precedents in the English law related to corporate rights are very few, and perhaps the main case is the Fulham Football Club, next slide please, versus Richards, which deals with the law on campaign of 2006, where the shareholders of the company had the right to petition the court on behalf of the company, saying that the interests of some of the shareholders have been unfairly prejudiced. So the shareholders of this football club, they have filed a file with a court against the president of the Football Association because he was not an authorized agent in the case of a transfer of a football player. And that association president, the chair of the association, tried to stop that dispute, saying that there is an arbitration clause or caveat in the rules of the association. The High Court of England granted the stay. The club appealed on the grounds that the article concerned a whole class of shareholders, and therefore potentially it concerned the interests of other shareholders that did not participate in that dispute. A court of appeal held in favor of the High Court and upheld the stay granted by the High Court. It said that it has to be decided in arbitration. In the decision of the Court of Appeal, there was a reference to the fact that in the law on the companies there is no exception that prohibits the parties to resolve such disputes in arbitration. And Lord Justice Longmire, you have the quote here, said, "I cannot see that it is necessary in the public interest that agreements to refer such disputes about internal management of a company should in general be prohibited." And why it is necessary to prohibit arbitration agreements about such disputes related to the stakeholders' interests. The Court of Appeal distinguished, though, between the arbitrability of the subject matter and the remedies that our arbitral tribunal could order. And in fact, they said that the dispute would not be rendered inarbitrable because the tribunal's powers to grant relief are narrower than those of the courts. It's just that those issues that the arbitrators could not resolve would just stay outside of arbitration and in the future would be resolved in a public court. That's basically all. That's basically briefly about arbitrability of corporate disputes in London.
Thank you. What about trends? Are you observing any trends? What do lawyers think too? Expansion or narrowing down of arbitrability in the English law? I would say the trend is towards expansion. The courts actively support jurisdiction of arbitration institutions and arbitration in general. So the basic assumption is that everything is arbitrable with the exception of some clear specific issues, for example, something involving public policy. That's quite remarkable because the way the text appeared, public interest, this is quite a bit of judgment call here. And if our legislation had the same phrases, probably our cases would go in all directions. So I think I commend your approach. Quite sophisticated, but at the same time quite classic. In 2006, The commission that oversees the situation with laws in England looked into the matter of amending companies' law to include arbitration clause in articles of association of companies. At that time, this was met with quite a resistance from the legal community, and this provision was not put in the law. However, the right of a company or shareholders to do that, then it's possible, but it's not mandatory. There's a question on the screen. Semen Yatsenko is asking what about bribery. What's the situation with the bribery? Criminal prosecution, then it's up to domestic courts to hear a case. And arbitrators do not have all the capabilities that prosecutors, investigators have in criminal proceeding. Quite an interesting aspect. Okay. Now we're clear about England. Let's talk about Ukraine. And Artem, I would urge you to listen attentively to our next speaker. Maybe this will be Yulia's presentation maybe will be useful in the context of English experience, and Yulia Atamanova will be speaking about situation in Ukraine, corporate disputes. Thank you, Markian. Good afternoon, everyone. First of all, I did not write any articles about arbitrability of corporate disputes. I'm one of those who never wrote an article about that. I wrote articles about corporate rights and corporate disputes, but not arbitrability. Maybe this is going to be my next article. 3 years ago, as far as I remember, this platform specifically had Serhiy Hrishko presenting on arbitrability of corporate disputes in light of amendments to procedural codes. And there were high hopes at the time for increase of disputes in Ukraine heard by ICAC, corporate relations disputes. And I was wondering, so what happened in the course of these 3 years? What changed? Are the practices really developing? Court practices, arbitration court practices, referring cases to arbitration. And initially, I hoped that we will have the trend to resolution of these cases, and later there was certain frustration, a lot of unanswered questions, what to recommend. As a lawyer, as an arbitrator, can a specific case be referred to arbitration, and what remedies can be applied in a specific case? So that's my introduction. I have slides to emphasize certain points, but for the most part I will be speaking. We have a little bit of a delay on the slides. So 3 years ago, we understood corporate disputes as pursuant to Article 20 of the Commercial Procedure Code as disputes between parties about creation, suspension, termination of a legal entity. These were disputes, therefore, were seen as arising from that definition. And court practices in the course of these 3 years and academic research went in the direction of expanding the definition of corporate disputes, not limiting to paragraph 3 of the article of the code. These are disputes about the deeds, about the shares and corporate rights, disputes about collecting property from unlawful possession, claims about collecting damages caused to legal entity by a public official, registration, disputes, registering rights to shares and corporate rights. And if we look at Article 20 of the Commercial Procedure Code, we'll see that corporate disputes include much more, include a vast number of corporate disputes. But for the most part, the debate revolves around paragraph 3, internal corporate management disputes. And if we look at Article 22, which for us is a defining one, defining which disputes can be referred to arbitration and which cannot, all disputes can be broken into 3 categories: unconditionally arbitrable, conditionally arbitrable, and inarbitrable. Inarbitrable disputes are those that raise public interest to some extent. This is state registration and registration of securities right, challenging those registrations and so on, and challenging contestation of decisions of a legal entity, which includes challenging against the decisions of the general meeting of the company, relatively arbitrable. This is pursuant to paragraph 3, part 1, article 20, and unconditionally arbitrable, that's part 4, paragraph 1, article 20, on shares in particular, and so on. And if we look at unconditionally arbitrable disputes, a few examples, we had a few examples before amendments to procedural codes, and there are decisions from 2013, 2014 that recognized disputes arbitrable emerging from deeds, from contracts. And this is the smallest category of raising issues. It raised least issues. But now I have other questions as a lawyer. A question: amendments to registries raise issues of protecting rights. Registering information about the rights, about shares, about equity capital. So very often it has to do with certain registration actions. And after the Grand Chamber's decision, and now in order to receive proper remedy, you need to file a claim to estimate the amount of equity capital and the sizes of the shares of shareholders. So when shall the claim be submitted? To terminate sale and purchase agreement of a share, or on amending due to the change in the size of the share. So for someone to receive a remedy and to have it enforced, there has to be a claim raised about changing of equity capital. But this is about public interest now, and this is the category of the disputes that has to do with court proceedings, with adjudication. How will that be resolved in the future? This is open for debate at this point. This is quite an interesting decision that isn't directly connected to arbitration, but this is a decision from domestic court of arbitration. But I decided to raise it here still because this was a classic claim about amendments of the sale and purchase of a share of equity capital, and there was a decision of the domestic court of arbitration which was later contested. And if we look at paragraph 48 of the ruling of the cassation court, such a dispute that is about a deed on the share was classified as pursuant to Part 3, which is something that is not under the jurisdiction of the domestic courts of arbitration. And this presents arbitrability constraints. So I think that there's a risk for the future development of situation. I think it was a wrong thinking behind this decision. We need to talk about that. And disputes emerging from deeds cannot be classified pursuant to Part 3 simply because they pertain to corporate rights only. Next, corporate governance disputes, which is Part 3 of the article. First of all, there's a limited number of parties involved. There were 2 decisions in the registry of court decisions that we managed to find. The decisions were on arbitrability of corporate disputes. One of them was heard by an appellate court in Odessa region, and it was a claim to declare agreement void between a limited liability company with a third party due to the fact that the director exceeded his powers in the amount to which the agreement was concluded. So he believed that his corporate governance right was violated, and the first instant trial denied the initiation of the case, and the Court of Appeal left the trial court's decision unchanged. Since, on one hand, this involved a third party, it was not only a dispute between the associates, but the Court of Appeal also looked into whether there was an arbitration clause between all of the parties involved. And it was said that the disputes have to be about the agreement exclusively, even if it's pursuant to Part 3 of the article. It's a corporate governance matter, and it's hard to think of what kind of disputes would we have if there's no corporate agreement. Next, the form of the arbitration agreement. The safest variant, there are two safe variants. It's either when everyone has a arbitration clause and signs it, or if there were claims submitted and all of the members of a company are participants of the dispute. There's been active discussion about including arbitration agreement into charges of association. The way I see it, this is quite a dangerous recommendation to recommend to the clients to write it in the articles of association and say that's sufficient. First of all, there are risks with identifying parties and identifying what is the definition of charters of association in line, articles of association in line with Ukrainian legislation, and whether that's a decision of a legal entity or whether it's an arbitration agreement between the members. Can there be an articles of association between arbitration and the parties, and what disputes will be covered by such an arbitration agreement, what kind of contractual relations, what kind of disputes. even if we give an extensive list of those potential disputed relations. And we gradually might conclude that corporate agreement and disputes emerging from it is potentially most arbitrable disputes. And there were amendments made this year in July to the law on limited liability companies. The amendments read that the party to corporate agreement can be a company and third parties, and the laws that joint stock companies did not have the similar amendments, and we can see this distinction here. We have a good mechanism of including of arbitration clause into a corporate agreement for limited liability companies when a company is a member of such a corporate agreement. At the same time, regarding agreements between the shareholders of a company, there's a major question whether, with the absence of the clear provision in the law, can analogy be applied. And it's quite disputable because there are specific provisions for certain types of companies and businesses, and the nature of legal relations differ. And I'm nearing the end of my presentation. Previous slide, please. This is a summary of corporate disputes that are inarbitrable, challenging companies' management decision, registration actions with relations to shares and other corporate rights, declaring void of deeds entered into by the head of the company with the third parties, compensation of damages caused to legal entity to actions or omission of action of an official, requesting a share to be collected from illegal possession, and obligations with regards to securities. And draft law 5347 was mentioned by Markian. It was registered last spring, and I'm quoting some provisions from it on corporate disputes. So what is suggested? Leaving out part 3, paragraph 3, and not applying it to arbitrable disputes, and there will no longer be requirement to have an arbitration agreement signed by all of the members and the company itself, the legal entity itself. However, if we think about whether this will lead to the increase of the number of the disputes that can be referred to arbitration, well, this can be to some extent. You only have 30 seconds left. But I think that there won't be too many, because the disputes contesting the decisions of a legal entity, they will not fall within this category. The way I see it, there could be disputes if these are about protecting the rights to dividends, something that doesn't have to do with contesting the decisions of the general meeting of the company. And I think that due to these peculiarities of charters or articles of association, and including the arbitration clause into it, we think that should be amendments made to the law on international arbitration, which should specify where arbitration agreement can find its place in articles of association in particular. Thank you.
Colleagues, if anyone has questions about arbitrability of corporate disputes, let's do it later. Now let's refocus our attention into improving arbitrability, arbitration attractiveness. Remember, please give us the slide about that survey that Mr. Sullivan has mentioned. There was some interesting information about the attitude to the International Arbitration, and there's a question about whether people believe that new specialized arbitration institutions should be set up in Ukraine. The answer was 50-50, while the answer to whether investment courts should be set up in Ukraine, the respondents 60% said no, only 28% said yes, and 12 could not decide. Our next speaker is Christopher Campbell Holt, member of the Consultative Council from the Astana International Center, who will tell us about Kazakh experience of increasing investment attractiveness by developing arbitration. Christoph?
Event today. I start with an apology for not being able to attend in person. I very much hope another time, if I'm invited, to be able to come and see you all in the flesh. I have been now living in Kazakhstan, in fact in the Sultan, formerly Astana, the capital city of Kazakhstan, for coming up to 5 years. And my job was to go out there to set up for a new international financial centre called the Astana International Financial Centre, an international standard common law commercial court, following principles and norms of the systems in England and Wales, and more generally in the common law world globally, and also to set up a separate independent international arbitration centre. I hope what I have to say now briefly will be of interest to everyone who's participating in today's event, not least because of what's just been said about possibilities or people's perspective of whether Ukraine perhaps should have its own similar international arbitration centre. And secondly, because so far as we approach the end of our 4th year of operations for our International Arbitration Centre, or IAC as we call it for short, 37 of our cases have actually involved parties or investors with relationships, business or otherwise, specifically with the Ukraine. Our arbitration centre is really open to everyone around the world, but specifically from the Eurasia and Eastern European area. One of the key, most important factors when setting up an international arbitration centre to increase investor attractiveness to a country or to a region is to ensure that you create infrastructure which is absolutely with guarantees in place, appropriate guarantees in place, absolutely independent, impartial, and without a question, in 100% of cases, can be relied upon by investors to comply with the very highest international standards of the rule of law. We, in the 4 years that we've now been operating our new arbitration centre in Kazakhstan, with parties, as I said, from the Ukraine and other parts of the region, have noticed a rise in particular trends in arbitration practice. I won't talk too much specifically about the rules in the limited time that I have available today, but at a high level I can explain that there seems to be, in our more than 700 cases, by the way, now at our centre, an increased reliance on expedited procedures. We have one such procedure in our rules in Kazakhstan for disputes up to the value of $5 million US. And this has proven in practice to be enormously attractive to investors coming to the region, to have a specialised fast-track procedure for the resolution of their disputes. There is an increased reliance upon the appointments of emergency arbitrators. In our case, we appoint emergency arbitrators within 24 hours of receiving an application. There's an increased number of cases using interim relief measures, which are provided through our rules at our centre, and those have all been enforced, and I'll quickly come to enforcement in a moment. Increased reliance on summary proceedings. Multiple parties and multiple contracts have come up increasingly in recent months and last year or so. Our centre has been relied upon more by parties for the actual appointment of arbitrators, either because the parties cannot agree or they simply need some other form of assistance. Enforcement is critically important, and this all goes down to building the trust and confidence with investors. There will always be investors that will come to a country or a region for whatever reason, but if you can provide guarantees in law, in our case the Constitution of Kazakhstan was amended, and that often is necessary to provide the legislative teeth, if you like, and protection for investors coming to a country. We then implemented a new specific arbitration law which was separate from the other arbitration law of Kazakhstan for the Republic of Kazakhstan to be effective within our financial center territory in the Sultan, Kazakhstan. And we have backed that up with rules, the right people in the right places who have international reputations for independence and impartiality in arbitration proceedings, with a world-class panel of arbitrators and a chairman, Barbara Doman QC, with more than 40 years international experience of such things. But enforcement is absolutely critical. What is the point going to the trouble of a sometimes lengthy arbitration proceeding if in practice it is very difficult or sometimes impossible to actually reach the assets or to receive the money, if it is money, that is being awarded at the end of the arbitration proceedings? So in our case, we created a separate, independent of the local system of Kazakhstan, independent of the local legal and judicial system of Kazakhstan, an international common law court, which is responsible for, among other things, in recognition and enforcement of our arbitration centre interim and final arbitration awards. And so far that has been delivered to 100% satisfaction of the parties in disputes for enforcement within the entire territory of the Republic of Kazakhstan. There's no interference or even a suggestion of interference or any connectivity whatsoever to the local judicial system when it comes to enforcement of our decisions, which are final and cannot be supervised or appealed by anyone within the Republic of Kazakhstan other than our own international standard common law court. An emerging trend, which is not just familiar perhaps for people in Ukraine and for people of Kazakhstan in this region, in Eastern Europe region, is the heavily increased reliance on IT, on digital technology. Now, this is a topic which some people get very enthusiastic about. I try not to become so enthusiastic because it's something that we deal with on a day-to-day basis during the operations of our arbitration centre. Throughout the COVID period, of course, 100% of our disputes have been resolved using digital platforms. So using video hearing technology, using our digital platform, we call it e-Justice, but other centres have their own name for a similar system, which is effectively an online database with secure login details for parties and judges and arbitrators to access papers, to file papers at the touch of a button, and in our case it's free of charge. So the reliance on IT has proven in our instance to be very successful. It has accelerated the ability of arbitrators to come together in our practice in Kazakhstan and to resolve disputes more quickly. It's been particularly effective with case management proceedings leading up to arbitration hearings. And the other aspect I wanted to draw upon very quickly in the time I have now is not just relying upon arbitration to resolve disputes or courts, but to look for alternative forms of dispute resolution which can work together in a successful way if it's appropriately managed. And that is, in our case, is mediation. We have an arbitration mediation procedure at our arbitration centre. It, again, is being increasingly relied upon by parties to disputes. So if for some reason the case starts with an arbitration, the parties decide for whatever reason they want to move to mediation, they can do so. And this is being able to happen in our centre within 24 hours of parties making such a request. And the mediator for our centre unusually is different to the different person from the one or three or other arbitrators who have been considering the dispute during arbitration proceedings. So I mention all of that as an indication of what has been achieved in Kazakhstan, what I believe can be achieved if the will is there to do this in the Ukraine. And with a hat on that, we do have significant business or users at our centre from the Ukraine. And I hope that what I've had to say has been of interest, and I'm happy to take any questions.
Thank you, Chris. Unfortunately, we are very short on time, so we will have to move on. I think our session is limited online, so we really have to move on. But we will continue discussing. And no, sorry. You see what is written, that we have to be in a rush. Пане Сергій Войтович, партнер Грищенко та партнери.
Sergey Vitovich, Grishenko Partners, your presentation. Now, unfortunately, we're really very limited in time. Please tell us about your thoughts, about what you think about the place of Ukraine as in international arbitration. Well, let me start by saying that I have not heard of a single case now where when Ukraine would be a place for investment arbitration. Maybe it exists, maybe it is confidential, and we have no information about that because several arbitration regulations would allow us to do it. For example, the ICC regulations, Stockholm, the regulations of UNCITRAL, the ICC regulations allow for the parties to choose the place for Ukraine as the place for investment arbitration. If we try to answer the question about whether one can widen the circle of arbitration proceedings in Ukraine, arbitration disputes thanks to investment-related cases, I would frankly tell you I've been thinking about that issue and I don't have a clear answer, unfortunately. However, I do believe that one should try. And we, the arbitration community of Ukraine, we're interested in that because many investment-related cases we have had it for many years with some Ukrainian elements, and they would be heard in other places instead. Now, what from a practical point of view? Because in this problem there are two sides, the legal one and the practical one. The practical one is the most complicated. From a practical point of view, what could be interesting for the parties and primarily the potential claimants, investors, to have Ukraine as the place for arbitration, investment arbitration. I think that first of all this is reducing the cost of arbitration, at least partially, because look what we have with the investment arbitration, with the cost of it in the recent years. The budgets of investment cases have grown dozens of times, and not only I say this, but you can read what we had about 20 years ago and in the Generation Ukraine decision of the arbitration court and how they characterized the reasonable arbitration costs or expenditures. So there is a hope, I believe, that if we have professional and good quality arbitration center, which is not too expensive, then we have some chances for it. It can happen that it's hard to be very optimistic in that, but at least several cases on the basis of direct investment contracts, we could get them, I believe. From the legal point of view, if we look at it, what do we have today? Well, here we have to look at the law about whether there are any limitations or bans. Arbitration regulations, the ones that exist now or that would be, as well as what is also important is the case law, and primarily as regards the cancellation of decisions. Do you think that the existing laws of Ukraine are they sufficient in order to have that? Well, there is no direct prohibition in terms of hearing such cases in Ukraine. I don't see that in the law, in the Ukrainian law. No direct limitation of arbitrability. I don't see that either. However, if we look at it from the point of possible jurisdiction problems, for example, if you look at the subject of competence, or perhaps what the law on international commercial arbitration says is not enough in itself. As regards the subject matter and the competences, yes, that's more or less all right. At least it has the words investments and the word concession agreements and the broad commercial terms. But as regards the subjects, the entities, that's very limited there. Now another element is arbitration rules. Well, here we can have two different possibilities. Either to create a certain independent center like the ones that recently has been set up in Bishkek, the Court for Commerce. They set it up in 2019. Or such centers as the one they have in Dubai or in Astana. Well, unfortunately, I have not received an answer to the question about whether in Astana they have had any real investment disputes. Christopher said Christopher said, and statistics is very impressive, but whether they have had disputes between the investors and the host countries, well, it's not very clear because unfortunately I do not have this information. I don't have it for Dubai either. For Bishkek, I think that it's too early to speak about that. Well, for Dubai, we may not have this information at all. Well, things are being transformed there, but as far as I understand, they're transferring their cases to another Dubai center, the LCIA. So, the simplest solution, I don't want to advertise anything, however, I see a simple solution. Investment rules in ICAC as a recognized regional center that already has, the way I see it, quite a competent composition of arbitrators who can hear not only commercial but investment disputes. Will it be realistic? Will we have something if this can be done? Well, we may have a couple of cases in the future. So that's in conclusion what I wanted to say. Thank you. Well, I think that we should listen to Mr. Sullivan here, and perhaps to start drawing the line, because according to our rules to our agenda. Very briefly, because there was a question about such things. We have had such investment-related disputes in Ukraine. There has been one, according to an agreement between Russia and Kazakhstan, where I was the only arbitrator, and where ICAS of Ukraine, in fact, provided administrative functions according to UNCITRAL rules that the parties had agreed to after I was appointed and I started procedural communication with them. The case ended in a settlement 6 months later between the claimant and the respondent, and I want to add that after that I received an even letter of gratitude from the representatives of one of the parties, saying that the process, the way it was organized, they were completely happy with it. What I'm saying is that there is a category of investment disputes between a number of countries to which we're quite close in terms of the legal nature and culture, where they feel, well, they probably can feel at home, can feel comfortable. That's why I support this idea. I think that ICAC of Ukraine should really think about this idea and to really discuss it separately inside the legal community. And later, I agree that it should have some prospects. Thank you. Thank you. Thank you, Tatiana. Sergey, see, I wanted to say that
Хотіли запитати Кріса, власне, в частині тих.
My question is, you have shown us very impressive statistics about the activities, arbitration activities of your center. But could you please specify whether the arbitration cases which you mentioned include any specifically investor-state disputes between investors and host states?
The answer is yes. Thank you very much for the question. It's a limited number of cases, but yes, we have. And I can say we had our first such dispute in our second year of operation. And very quickly, if I can add to that, to what was just been said,
Go
the
ahead,
importance of having your own independent center is about reputation and building a credible international standard reputation for a country to attract further investment. That all comes as a part of this type of setting.
Thank you very much.
Thank you, Chris. Дякуємо. Ну що ж, на
Well, I think that, dear colleagues, we will end our very exciting session. I hope you all have liked it. The speakers are staying here. For the conclusion, we want to thank you all. Let's thank all the speakers. And Mr. Sullivan, we really want to hear your thoughts, your impressions about the work we have done today.
Dear ladies and gentlemen, let me begin with talking about the second session, Markiyan's session. It was such a pleasure to hear from the speakers who said that we do not need to invent a wheel in terms of investment arbitration. We need to do that at ICAC, and we're actually thinking about that. We think that we can do just fine with amendments to the law on International Commercial Arbitration Court. Article 1, paragraph 4 says that the law can define another jurisdiction of arbitration. Investment disputes are disputes between an investor and the state. So there has to be an investment agreement, or there needs to be an umbrella agreement between, for example, Turkey and Ukraine. And let me reiterate something which is very close to my heart. In 2018, the presidents of Ukraine and Turkey signed a new agreement on protection of foreign investments. And there was an article on proceedings. Istanbul Arbitration Center was put in the agreement. The center has been up and running for 4 years, and in 2018 it was operational for 2 years. I went to the launch of the center. And we see that Turkey is offering its arbitration institute. It says, we already have an arbitration institution, please come to us. And instead of Ukrainian institutions, it was written other arbitration institutions. This is Ukrainian government's standing on our arbitration institutions. And Tatiana Slipachuk said something important. We need to raise awareness in the legal community about the need to develop international arbitration in Ukraine, investment arbitration in particular, and jointly we can get through to the politicians, those who are decision makers. Session 2, in my opinion, was very interesting. Some burning issues were raised. Something very relevant for Ukraine. It would be great if Artem and Yulia, two wonderful people, could elaborate on how investment disputes could be made part of arbitration. For 3 years, now we haven't had a single investment dispute. 3 years is not that much, actually. It takes time to sign an arbitration agreement. It takes getting to arbitration. It takes 4 and 5 years, so maybe we'll finally get an investment dispute. But so far we haven't had one. Corporate disputes arbitrability, I don't know about changes there, what change is going to take place, but this is, well, we have the facts. And I also am deeply concerned with the issue of bankruptcy. And Amirat said, very directly, she said, there has to be an arbitration award because we have ECHR that is going to protect us. Hell no, I don't think this is going to happen. As a judge on the European Court, I would never recognize non-enforcement of Polish arbitration if it's a case of bankruptcy. If the debtor is a bankrupt, nobody prevented the creditor to do something with the law. Justice is not just me rushing to court, shouting about infringement of my rights. Justice and access to justice is about domestic legislation. And the law says that the claimant doesn't need to go to domestic court of arbitration, but instead to a domestic court that will adjudicate on the matter and that will order the collection of the damages. Markian asked where to go. It's quite a sophisticated matter. Also, I think that we don't have enough time for proper consideration of arbitration related matters, in particular with the view of the online format of the event. But I've been part of ICAC for 30 years, and I'm interested in those matters, and I keep learning. I look up the information that I need in my work. And you all here are professionals. You are better than me. And you're also interested in the matters of arbitration. This is what our conference is about. And I'm very grateful to all of you. And Artem, I'm going to have a conversation with you on the sidelines. A good one. A good one. Don't be scared. And session 1. Which was also very interesting. There were different perspectives there, and I think the bottom line was that arbitrators, legal communities, parties to the proceedings, arbitration institutions, if you all fail to use modern technologies, you are not going to have clients. You won't be able to work with arbitration institutions, so you have to learn. And the colleague from Kazakhstan actually was talking about that. He said that one needs to master IT, even if someone might not be willing to do that, like me, for example. But that's the future. And what is the future of arbitration? Tatiana Zakharchenko and Markian touched upon that. A few years ago, we went to Munich, at which German, Ukrainian colleagues were discussing arbitration. It took us half a day to discuss development and to say how great it is. And then an American professor says, arbitration is dead. You have 15 years tops. There's advanced technology, e-trade, etc., etc. And you're talking about all those lawyers and parties. Well, that was 15 years ago. He said, we're left with 15 years, and it's been 15 years now. Arbitration has changed, and Yulia made a point. If fundamental principles of arbitration find their way in a new technology-based arbitration, arbitration is going to live. So I would like to urge you, lawyers, arbitrators, Secretariat of ICAC, there's time for new endeavors in the area of digitalization. So I'm very grateful to you for participating in this event. I'm very grateful to the moderators, the speakers of the first and second session. You inspired us by your presentations. I would like to thank interpreters. It's a great thing to see that most of the people speak English. But it was clear to me what you were interpreting. Unlike other companies, I'm grateful to our partners who have been helping with us. The 28% of respondents that we saw in the survey, this positive result, this is thanks to our colleagues and partners. I'm also grateful to the studio who helped us organize our event at high level. And I wish you all the best of health, professional and personal successes. Thank you. And last but not least, for those whom we have here with us, there's a